If she did what she's being accused of, I know that she's ready to pay the price. I know that she's going to do whatever she needs to do to pay that price. Our fear, my biggest fear in all of this is that she's not going to get a fair trial. She's not going to be treated fairly. She's going to be made an example of, and that's my biggest fear.
Those are the parents of Reality Winner, the 25-year-old NSA contractor accused of leaking classified information to the media. The document sent to an online news outlet containing information about Russia's meddling in the U.S. election. Joining me now is her attorney, Titus Nichols. Counselor, thank you for joining us.
Thank you for having me, Chris.
Do you and does your client believe that she is not guilty?
I think the important thing to remember right now is that we're still at the beginning stages of this case, so we can't get into the merits of the case. What I do believe is that we're going to be fully prepared for our next hearing, which is going to be Thursday, and will be in regards to whether the judge will allow her to be released pre-trial.
Well, we'll talk about that in a second. But look, while we must respect the concern of parents, 25 years old, obviously an adult, but very much still their child, I get their concern. But the facts as laid out in early reports here seem pretty clear about the action and the intentions and even the potential admission of guilt by your client.
Well, another thing to remember is that we don't have the facts yet. All we have is a press release that the Department of Justice issued on Monday, the same day that Ms. Winner had her first initial appearance. And then there's been discussion and dissemination of so-called documents on the internet. As of right now, the best thing to do is just focus on what comes out during the actual court proceedings.
Well, look, of course, you know, justice is fairness under law. You want the process to take its place. But if it's true that when first confronted by officials, she said, yeah, I did this, whether it was a crime of conviction or something she felt she needed to do, what else do you need to know?
Well, the important thing is that we don't go into a rush in deciding what's true, what isn't true. The most important thing is making sure that she receives a fair trial. That's going to include having the facts go to the jury, and then the jury decide what is and what isn't true.
So you would take it all the way through trial, even though that may compromise what kind of sentence deal you get than if you make a deal earlier?
At the end of the day, my job is to advocate zealously for my client. That's to do whatever is in her best interest. So I can't say what my strategy is going to be or what we're going to shoot for. At this stage, we're taking it one court proceeding at a time. And
just to get a response to that earlier question, do you deny the reports that she admitted that she did this?
Like I said, right now it'd be too premature for us to comment on anything regarding the merits of the case. The only thing we can focus on is just being prepared for court and doing what's in the best interest of Ms. Winner.
Right, but I mean, you know whether that's true or not. You've spoken to your client. Does she say that she admitted it or no?
There's lots of things that I might think I know, but at the end of the day, we're still at the beginning of the case. It'd be speculative at best for me to say, I know for 100%, this is a fact, I know that's a fact. All I know is that we're preparing for our next hearing, that we're going to give her the best defense possible.
And in terms of why she should be held versus released, what is your argument for why she should not be in custody, especially in light of the reports about the facts, which, again, are pretty clear on the face of them at this stage?
The argument's going to be in line with the federal statute in regards to pretrial release. We're going to explain to the judge the fact that she's not a risk for flight, not a risk for intimidating witnesses, or committing any new state or federal crimes. At that point, it's going to be up to the judge to make a decision whether she should be released pretrial, and if so, if he'll put conditions on her release.
And what are you asking for?
I'm going to ask that my client be released pretrial so she can assist us in preparing her defense.
And what about her being a flight risk?
Specifically, I think it's already mentioned that her passport was confiscated by law enforcement. Plus, with all of the worldwide media attention she's received, there's little to no chance she can go anywhere without anybody recognizing her.
And a little bit of what is known about her is obviously by her own doing, right? These tweets have now come out. You know, the account had a different name, but it's the same picture. It seems pretty clearly to be hers. She had an obvious political animus towards the president. What role do you think that these tweets will play in a reckoning of the facts of her case?
Well, the federal rules of evidence have very strict rules for what documents or so-called social media pages can and cannot come into trial. So while we can talk about them all day long on television, when it comes to the actual trial or the court proceeding, that's going to be a different matter. Now, for a better idea of who she is, I think her parents have done a phenomenal job in explaining to the world who she is as a person, not just this figure that's been created in the span of a week.
Understood, and parents are always going to have a positive image of their child, especially in a situation like this. What's your best case for the audience as to why those tweets shouldn't come out?
Well, it's not a matter of what I believe the audience should know. I just know that if we come to trial, we're going to fall directly in line with the federal rules of evidence as far as what is and isn't admissible.
Right. I'm just saying we've certainly seen statements of intent come in from lots of different sources. Tweets wouldn't be beyond that level of recognition by the court. But again, remember, I'm asking you some of these questions lawyer to lawyer, but you've got parallel situations of scrutiny going on here. You've got the court of law. You've also got the court of public opinion.
Absolutely, and the best thing that I can do is not be distracted by any types of political statements or social media statements and just focus on exactly what the law says, specifically this statute, 18 U.S.C. 793E, which the government's going to have the burden of proving beyond a reasonable doubt. That's what my primary focus is.
Understood. The burden is certainly on the government, and this is a forum for you and for your client to come on to make arguments as you see fit. Thank you for coming on New Day today.
Thank you. I appreciate it.
Allison.